Welcome to the Santa Barbara Museum of Natural History's Essentials of Estate and Legacy Planning Workshop. I'm going to turn it over to President and CEO of the museum, Luke Swetland.
Great, thank you, Sarah. As you can see by the name on my video, I'm channeling our Planned Giving Officer, Rochelle Rose. It's really a delight to welcome you all here to the second annual Estate and Legacy Planning Essentials Workshop, presented by the Santa Barbara Museum of Natural History. Today, we have 4 experts from a variety of fields. They have very generously offered to give you some great advice and information about estate planning, and they're going to be leaving you with a number of free tools that will make life easier as you leave the conversation today and continue to think about these issues. It's really our pleasure to provide this free community education under no obligation, courtesy of the museum's Planned Giving Advisory Council and our development and legacy giving staff. Of course, I hope you might consider leaving a gift to the museum in your estate plans to help ensure the future of this great 104-year-old institution. I'm delighted to report that for the time being at least, both the museum and the C Center are open indoors and out. We have added engaging exhibits and activities at both campuses, so we continue to be a safe and trusted place of respite, of education, and of fun for our community. These are indeed extraordinary times because of the COVID-19 pandemic and the resulting restrictions and shutdowns. All of us are thinking more about our own health and our future, and about the kind of legacy we wish to leave behind when the time comes. This will be an information-packed 2 hours that will provide a lot of useful insights and advice. Thank you for your attendance. Thank you for your interest in the museum. And with that, I'll turn it back over to my colleague, Sarah Clement.
Thank you, Luke. It looks like we've got 27 participants, which is wonderful. I'm so glad everyone could join us today. We so appreciate your interest. And in just a moment, I'm going to turn it over to my colleague, Rochelle Rose, Development Officer at the Santa Barbara Museum of Natural History. And as always, if you're having any technical difficulties, please email me at sclement@svnature2.org.
Great. Thank you so much. First of all, Sarah, for being our Zoom master and registrant. And I want to also thank Luke, our president and CEO, for his welcome and update on everything going on at the museum. I want to welcome you to our second annual Essentials of Estate and Legacy Planning Workshop. Last year, we had an overflow crowd of 60+ people in person at the museum's beautiful Santa Barbara Gallery. We wanted to continue our tradition of providing this community education and outreach, so we are glad that you are Zooming with us today. I wanted to share with you the results of a 2019 research study by caring.com, which indicated that 40% of Americans have an estate plan in place. So that means that 60% of US adults do not currently have estate planning documents such as a will or living trust. When it comes to life estate planning, we are understandably conflicted. It forces us to confront our mortality and consider the future of those that we leave behind. If you happen to be part of that 60%, that's okay. This workshop is a great informative first step. If you are part of the 40% of Americans who do have a will or trust, it's always good to review and update your documents and also keep informed of new laws that may affect your situation. I hope that you received our numerous attachments via our email invite, which includes handy checklists in updating or creating advanced care health directives, legal documents, the roster of our speakers, and suggested bequest language. If not, please contact me after the conference and after the workshop, and I will mail them to you. As Luke said, this will be an information-packed 2 hours. And as part of our housekeeping, I want to let you know that we will have a couple minutes, hopefully after each of our 4 presenters, for questions. And you can submit those questions via the chat function, which you will find at the lower, the bottom of your screen in Zoom. Also, at the end of the presentation, we will answer questions as well. If we don't get to your questions, please email me or phone me, and I will get back to you this week. Also, the intent of this workshop is not to provide personal legal advice. Please contact your legal or financial advisor. However, the links on the attachment should be very helpful to you, and I'm glad to share a list of referrals if you contact me after the workshop. Lastly, I want to wish you a happy Philanthropy Day, which happens to be today, which celebrates generosity and resilience. And I also hope that you might see a rerun of another SpaceX launch of our 4 male and female astronauts, which takes place right during our workshop at 4:30. Now let me introduce our presenters who have generously donated their time, expertise, and experience. In agenda order, they are Brett Piersma, estate planning attorney with Mullen Henzell LLP, Jackie Quinn, owner and founder of Quinn Fiduciary Services, Donna Dawson, accountant, owner of Donna Dawson CPA, and Denise Stevens, former investment plan giving professional. Now our first presenter, Brett Piersma.
Hello, everyone. It's a pleasure to be with you. And again, thanks for taking your time on this Sunday afternoon. It is beautiful out, and you certainly could be out there, but you're with us, and that's great. We appreciate it. It's my honor to present today and talk to you about really some fundamentals of estate planning, some items that many of you may already know, many of you who have estate plans, as Rochelle discussed and mentioned, some of you who don't, or some of you who have an estate plan but haven't looked at it for quite some time and may wonder actually what it says or what it even means. Maybe it's time to dust it off and take a look. Well, what I'll do today is I'll go over really some fundamentals and some things that are really not so fundamental. And what I'd like to do is we're going to start sort of at a 30,000 foot level, and we'll dig deeper and deeper and deeper and get into some sort of unique strategies. We'll talk about some changes in the law. Some of you may be aware of property tax changes, potential estate tax changes that may or may not go into effect in the next year and in the coming years. So we'll talk about those. And of course, I'll be available for any questions you may have. But what I want to do is actually share my screen, and I'm going to present to you with a PowerPoint. So hopefully that'll make it a little easier to follow. And so on your screen, you should see estate planning fundamentals and plus some not so fundamental strategies that we'll talk about today. So the quick summary of what our roadmap is going to be for today is as follows. First, I want to talk about the various types of property ownership and the fact that you can hold property in lots of different ways. And some of you probably have property titled this way in some of these different ways. And we'll go over the pros and cons of each of them. If anything is wrong on your screen, somebody please jump in and tell me, and or send me a message on the chat, and I'll be happy to fix it. But I think everybody should see the slideshow on your screen. We'll also talk about intestacy and probate. What do they mean? How do they work? What's the difference? And how do you avoid them? We'll talk about estate planning fundamentals like just trusts and wills. What are they? How do they work? And how do you handle tangible personal property in the middle of an administration of a person's estate? And how do you plan for where your tangible personal property goes? It's typically very easy to understand where your real estate goes and how to handle that. But then what about those very valuable pieces of jewelry or other things that you may have? And as I mentioned before, we'll talk about taxes. We'll talk about the changes to the gift and estate tax. We'll talk about Prop 19 and property tax. And then I'll try to do a little bit of justice to the big Secure Act that went into effect not too long ago that is in effect today. It's not changing. It's the new landscape for IRAs and beneficiary designation retirement accounts. And there's so many things to talk about in the Secure Act, but I'll really barely scratch the surface. But if you have a retirement account, and I think Donna Dawson will also talk a little bit about those things, but so important for you to take a look at your retirement accounts and your planning as a whole and how it relates to the Secure Act, because the Secure Act changes really everything. It changes the entire landscape. And last topic that we'll talk about is charitable remainder trusts. And the reason I put it in this order is because I want to show how charitable remainder trusts link to the Secure Act in the sense that we no longer have what's called the stretch out, but we can sort of recreate something like a stretch out provision by using a charitable remainder trust for your IRA. And that's kind of a unique strategy that we'll talk about, but I'll just briefly mention it. And if you have questions about it, I won't go too deep because it's pretty complicated, but if it's something that's interesting to you, certainly look more into it. And then I'll end with what I hate to talk about, which is when estate planning goes wrong, but it's such a great cautionary tale. I'm going to tell a personal story or an anecdote from my practice. And what went wrong and why and how to avoid it. But just before I begin, I just want to point out that on the bottom right of your screen, you should see my name and the firm that I work for, and my email address, my phone number is there. So you can certainly send me emails separately with specific questions about the topics that we're going to cover today. Okay, without further ado, the types of property ownership that you may be familiar with, obviously many people have their property in their own name, individual name. This is really the best. It's great to have property in your name because it means you have property, but it's the worst type of property title to have because it really means you haven't done any planning, or maybe you've done some planning, but you haven't planned and put your assets into your trust or where they should be titled. And so instead, your property is just held in your individual name. But what is this thing called joint tenancy? A lot of people have joint tenants on title, or it's several people named with as joint tenants with right of survivorship. So what exactly does that mean? Well, joint tenants with right of survivorship is a way to, in a sense, do some estate planning, because what you can do is put a person's name on title with you, so that if you pass away, it automatically goes to them with the right of survivorship. That's what that means. And it really shouldn't be any sort of replacement for estate planning, but it does avoid probate. And so if you have property and you're on title as joint tenant with right of survivorship, well, that triggers right away when you pass away. And so it is a way to make sure that you don't have a probate situation, but it's not a way to really plan for all of your assets. It really is particular to real estate. Tenants in common. Many people have investment properties or something that they purchased when they were younger with friends, or they went into business with someone and they purchased some real estate and they took title as tenants in common. Well, tenants in common, also oftentimes called TICs or TICs, really just means that your interest in the property is delineated as either equal percentage. If there's 4 of you, you each own 25%, or maybe you own less than the equal percentage. Maybe there's 4 of you and you only had a 10% investment, so you only have a 10% tenant in common interest. What these interests are and what this means is that your property can be transferred the way you want it when you pass away, because your 10%, let's say you own 10%, that 10% will be in your name when you pass away and will pass pursuant to your estate plan. So it doesn't really do any avoidance of a probate, but it is a way where you can make sure that your interest in that property goes to whomever you'd like. It doesn't automatically transfer to the other owners. That's a good thing and a bad thing for some people. And so tenants in common is a pretty popular way to hold property. And of course, in California, we have what's called community property and community property with right of survivorship, which simply means that when you own something with a spouse, that spouse really owns a community property share, as long as the property was purchased with community property assets, or it was purchased during the marriage with whichever assets were available to the marriage. And so community property really is a California specific thing. There are several other states that have community property, but all it means is that it's property owned with a spouse. And with the right of survivorship component to it, it passes automatically to that spouse and does not trigger probate. And last, really, the part that we're all dying to get to is the trust. When you have real estate, you really should have an estate plan. When you have any assets of any sort, you really should have an estate plan. And the kind of an estate plan to have these days, we really do recommend trusts. And so I'll talk a little bit more about what a trust is and what it isn't and how it works. But oftentimes you'll see people, certainly if you've purchased property recently, you may see that the seller was transferring property to you as the buyer, and the seller had it in their trust. It was the name of the individuals, trustees of the blank, blank, blank trust. That just means it was held in their trust of some sort. It could be a family revocable trust, a living trust. It could be an irrevocable trust. It could be any of these other kinds of irrevocable trusts that we put together, like QPERTs, qualified personal residence trusts, or IJITs, and legacy trusts, these kinds of things. But if it's in the name of a trust, then that means it's the trustee who's transferring it, or who owns it during that ownership. And so we'll talk about trusts a little bit more. But I do want to pause real quickly and talk about intestacy and probate, because this is something that people oftentimes are quite confused about. What is intestacy and what is a probate? Intestacy just means that a person passed away without an estate plan of any sort. They didn't have a will, they didn't have a trust, and so their entire estate, whatever they own, has to be really probated. And if they don't have any assets, then there is no probate. So intestacy just means dying without any estate plan. A probate is what happens when you die either with no estate plan, or if you were to pass away with just a will, or say you had a trust, but you didn't fully fund your trust. You had a house that was titled outside your trust and your main residence was in the trust. Well, that house outside your trust would trigger probate. And so probate is not avoided by simply having a will. The will can create the need to have a probate proceeding. The reason, and I talk to my clients about this quite often, they hear probate as a big scary thing to be avoided at all costs. It's the plague, it's COVID-19, it's the worst thing on the planet. And really it is. It's a bad, time-consuming, expensive process, but it really isn't the end of the world. We do it all the time and it happens. It's just not the most efficient way to get your assets to go to where you want them to go. And if you have a specific desire for where your assets go, that is not just the natural progression to your spouse or to your children, to your surviving children, per stirpes, which is what the default rule is. If you have some other wish or goal, then probate is not going to accomplish it. It's going to go where the legislature says it'll go based on what the probate code says. One common misconception, and I don't know where this comes from, but I hear it all the time, is that if you die without a will, the state takes your stuff. It takes all of your assets. It's not true. If you die and you have family of any sort, either parents or children or nieces, nephews, siblings, great grandchildren, your assets will go to them even if you die without an estate plan. It'll just have to be probated. So probate does not mean I died without a will and everything goes to the state. That's not what it means. We'll talk now here a little bit about estate planning fundamentals, and I have mentioned trusts here a couple times. A trust, in the context of a family revocable trust, is an instrument that is prepared for you that recites all of your wishes, all of your goals, all of your desires for where your assets go, and what assets you want to have in it, and who's the trustee of it, and what powers does that trustee have, and what happens at each stage of your life when you're living and have capacity, once you become incapacitated, once you have passed away but you have a surviving spouse, once that surviving spouse becomes incapacitated, and once that surviving spouse passes away. So each of those stages are planned for in an estate plan, and the assets pass where you want them to. Trusts are really probate avoidance mechanisms. If you have all of your assets in a trust, there is no court proceeding to administer them. And so they can save a lot of money for most families where a probate would consume a lot of resources. The reason probates consume resources is because there's a statutory fee that's applied to the value of the estate. So if you have a house and some investment accounts and an IRA, and your estate is worth, $1.5 or $2 million, you could be looking at $20,000 to $25,000 worth of probate fees and a year's worth of time in probate court to have it pass your family. So trusts avoid that. Wills do not, and wills are part of an estate plan along with powers of attorney and assignment deeds, assignments, documents, and transfer deeds. And the reason we have a will as part of your estate plan is because oftentimes people will have a trust and they'll put their assets in the trust, and they will then later on take a house out to refinance it, and then they'll forget to put the house back in that trust. So when they pass away, the house is now titled in their trust, in their name individually. So what happens is the will that we prepare when it's part of an estate plan that has a trust is the will says all of the assets that I own go to my trust. And so it's a pour over device is what we call it. So all that does is make sure that that house ends up in the trust and ends up going to where the person wanted it to go ultimately. But that pouring over does not avoid probate. So that will has to be probated. If the asset is above a certain value, then it will end up in the trust. It just will go through a probate first. Assets and transfer deeds, handling of tangible personal property. So all of your assets end up going into your revocable living trust, even things like jewelry and real estate and fine furniture and china, that sort of thing. The way we handle tangible personal property, or one way to handle it, is that we have you sign an assignment, and all of those assets that you own, you assign sort of magically into your trust. There's no formal document that says this china is, the title to this china or to this, nice couch, the way there is with a bank account, an investment account, or a piece of real estate. So instead, we have an assignment that puts everything in your trust, and then the trustee is instructed on how to handle those items. And you can express specific wishes now, and then change your desire all the way for the rest of your life. You can change who gets those things, and all you do is you prepare a letter that tells the trustee, hey, trustee, if when I pass away, I still own my grandmother's ring from the 1890s, I want that to go to my grandniece. And then you change your mind because your grandniece no longer wants it, and you decide to give it to somebody else. And so you just change your letters. You don't have to change your will. You don't have to change your trust. You just change that letter and you send it to your estate planning attorney. And so that's how we handle tangible personal property. Anything that you don't desire to go to any particular place, the trustee handles it and either sells it or gives it to whomever would like it. At the end of my presentation, I'm going to talk about an estate plan gone wrong. And part of that, I'll bring up this point of when to review. If you do have an estate plan, when should you pull it off the shelf and look at it? But essentially, when it comes to a trust, if you have an estate plan that involves a trust, you probably should look at it every 5 years or so. But you should also look at it when you have heard that there have been changes in the law. If you have heard, hey, there's been a change to the tax law, estate tax has changed, property tax rules have changed, or any sort of thing that you've heard on the news, or if you just are curious and you call your attorney and say, hey, is there any reason for me to take a look? All of those should be triggers to make you say it's time for me to look at it. But at the very least, if it's been 5 years, it's probably time to look at it, especially these past 5 years where so much has changed. In the past, where the law didn't change as frequently, we would oftentimes say, go 10 years before you take a look at it, because really the law hadn't changed much. But in the last 5 years, it has changed a lot. And so that's why it's important to review if it's been more than 5 years. The next topic I just want to talk about is taxes, and I will try to wrap this up very quickly because I'm getting close to my time. But taxes are an important part of estate planning. Some people plan because they want to avoid probate. Some people plan because they just have a really strong desire of where their assets go. And some people have those two things, as well as they want to figure out a way to avoid or minimize estate and gift tax. Well, what we have in our system now at the federal level is a combined estate and federal gift tax. And every person gets an $11.6 million exemption from estate and gift tax. And most people don't have more than that. So that really covers most people. So we don't have a whole lot of worry for a lot of our clients with regard to estate tax. We do have a worry about some other kinds of taxes like property tax, which we'll talk about. So the exemption amount, like I said, is $11.6 million per person, and it's per person. So a husband and wife each gets that amount of exemption. The law is set to possibly change. Well, I'll jump down to the fourth hash mark. It will change in 2025. It'll go back to a $5 million exemption indexed for inflation. That's set into the law. So it's going to sunset unless it gets renegotiated and passed again by Congress. But there's also a potential that with a Biden administration, depending on what happens in Georgia and with the Senate, we may actually have some estate tax changes in 2021. We just don't know. It's far too early to speculate, but we know what Joe Biden has said he would like to do, and we know what his proposals are, and they are to reduce the exemption down pretty dramatically. I've heard as low as 3.5 million per person, but possibly 5 million per person. And to make the rate above that up to 60 or 70%. So potential changes coming down in the next administration, but again, we just won't know until next year. Property tax, as you may have seen in the news, it took some time for the tallies to come in, but it looks like Prop 19 passed. What this means for most people is that the single most important asset that they own, which is their personal residence, will not receive a parent-child exclusion if the children don't want to keep the house and live in it. And this is a big deal because a lot of families think, great, I've got this home that I paid, $83,000 for in 1980, and now it's worth 1.4 million. And my kids are going to get it when I pass away. They're going to get very low property tax base, and they're going to rent it out and get some good rental income from it and have very low property tax. That's no longer going to be the case. It's no longer going to be allowed. They have to actually live in it as a personal residence. So that's kind of a big deal for a lot of people. It also changes some rules surrounding commercial properties. And there's a lot of potential downsides to this with regard to families with personal residence, as well as some rentals, and then maybe a commercial property as well. And so we are now advising some kind of challenging, unique strategies with regard to property tax and irrevocable trust, the potential to make a transfer this year before the law goes into effect next year, to capitalize on the current parent-child exclusion, which is that you can pass your property, your personal property, to your kids, your residence, and have no reassessment of property tax. And they can do that even if they're not going to live in it. So that's the current rule. That's what's changing. So there are some planning strategies around that. And again, if you would like to know more about that, you can contact me, or you can do some research or talk to your attorney about that. Secure Act. Again, I'm going to just really throw the most important bullet points up on the Secure Act. And it is that for IRAs, we no longer have this wonderful stretch that we used to have, where you could inherit an IRA from a parent, and you would get the RMDs would be for your life expectancy. So if you were in your 30s or 40s or 50s, you've got a 25 or 30 year life expectancy or longer, you can keep benefit of that growth and that interest tax-free, and you only get taxed on the distributions that you take based on your life expectancy. So now there's a new 10-year rule. That entire IRA has to be distributed by the 10th year, by the end of the 10th year. So that means it can distribute nothing for 10 years and then distribute everything at the end of that 10th year, or it can distribute a little bit each year, but it no longer can go for the life expectancy of the recipient. There are a few exceptions to it. And a surviving spouse is one of those exceptions. A disabled child you may have, or a minor, they will get a longer stretch out provision depending on which category they fall into. But for most people, the 10-year rule applies. And this is a big deal for people who have done estate plans where their retirement account is a huge piece of the overall plan. If they've got a house and some other investment properties and some cash and a brokerage account, and then this retirement account, oftentimes the attorney will have done some planning around all of those so that the retirement account either goes into a new irrevocable trust for the life of their child so that they can manage the distributions that way, or maybe something else was designed around that IRA. And so now is the time to look at that again, because with the stretch gone, it probably changes that plan. It probably makes the goals of that plan no longer workable. So the last point before I talk about my worst case scenario in a minute, or estate plan gone wrong, is that I want to show one possible way for people to recapture the stretch, and that is through a charitable remainder trust. The diagram's a little bit complicated, and don't worry about spending too much time looking at it or trying to figure out what it means. But the quick summary of it is that if you have a very highly appreciated asset, and this is where charitable giving comes in, especially with regard to the museum, that is producing some good revenue for you, but you know that if you sell it, you're going to pay a huge capital gains tax. A charitable remainder trust just could be the way to do that. You transfer that asset to this charitable remainder trust, and then you can sell that asset and pay no capital gains tax, and then keep a flow of income from the sale proceeds for a certain term. Lots of details on the rules and how that works, the term, and the residual amount that has to be available to go to charity. But point is that this is a strategy that works for people who are very charitably minded and also have certain kind of assets that have appreciated, and they kind of want to sell and get out of that business or no longer own the asset, but they don't want to pay a huge capital gain. It's also related to IRAs in the sense that you can name a charity as the beneficiary of your IRA. You can also name a charitable remainder trust as a beneficiary of your IRA. And that plan gives us the opportunity to recreate a stretch provision. So I won't say any more about that because it is quite complicated, but if you have charitable intentions and you have an IRA, or you have an appreciated asset that you're looking to sell and you don't want to pay capital gains, talk to your estate planning attorney, because we can put something together that meets all of your goals. And certainly if some of those goals involve beneficiaries that are charities, that would be a great time to do it, to make those charities the beneficiary. And the last point is when estate planning goes wrong, and here was a case that I'm still in the middle of working on, where the client did a great job of putting an estate plan together. Had a family, he was married and then divorced, and had a trust, dutifully put all the things he wanted in his trust. He titled things properly. But then over time, he didn't look back on it and make some revisions or revisit it when life changed. He got remarried. That's a key trigger. If you're going to get remarried, if you're going to buy new assets, or if you're going to sell something important, look at your estate plan again. If time has gone by, look at your estate plan again. If you've had a child or somebody's passed away, look at your estate plan again. And so he didn't until kind of too late. He also came down with an illness. So he had an illness, he had an estate plan, and he got married. And in the process of looking back at his estate plan and saying, hey, I should probably change that, which he began to do, he unfortunately passed away. His illness was worse than he thought. And so he passed away. And so what happened is we ended up having to do both a probate of a part of his estate that was not in his trust. We had a spouse who was not named in his trust, which is a no-no. If you have a spouse and you don't name them as beneficiary and you married them after you established your estate plan, they're an omitted heir or an omitted spouse. And so lots of bad things happen just in terms of the law and the default rules. And it all could have been avoided if he had looked at his plan a little earlier and had things updated in time. So if you have an estate plan, take a look at it. If it's been more than a few years, or if you think that some of these key facts and changes to the law may affect you, then take a look at it again. Nice to talk to you all. And if you have any questions, feel free to email me. Thank you.
Brett, we did have one question from a guest who I think you actually answered part of this.
Okay.
What happens, can you hear me okay?
Mm-hmm.
What happens in probate, cost, ? So maybe we could go back to your illustration of a $1 million estate, and that just the estate taxes would be costing around $25,000. Who carries the court costs and lawyer costs, say if a son and daughter were the beneficiaries?
Great question. So if you die with an estate of around 1.5 million or 2 million or so, thereabouts, and you have a probate situation, the fees that will be charged by the court and by the personal representative are not estate taxes. It's not that there's any tax at all. In fact, your estate would be far below the estate tax threshold. Instead, it would be it would go through the probate system, and for it to pass to, I think Rochelle mentioned, to your kid, who would pay those fees? Well, it would come out of the value of the estate, and the fees go to both the attorney who is handling it, and there's also trustee fees. So there's, I'm sorry, not trustee, personal representative fees. And so those fees are based on a percentage, and there's a tier. So it's a tiered schedule that starts at, I think it's 4% for the first couple $100,000, then it goes down to 3% for the next 800,000, and it's tiered. So all the way. So depending on how high you get, you pay a lower rate for the top portion, and so you have to run it through a calculator to find out what the actual fee would be. So I typically ballpark about a $1.5 million estate is between 15 to 20, and if you're about 2 million, it's more like low 20s, that range. So again, there's a calculator that we can run it through to find out for you. But again, those are fees that are applied based on the value, and they're automatically applied, and they're not taxes at all. They're fees, and they're paid from the estate. They don't before the thing goes to the kid. I saw a chat also pop up. I'll just answer that, Rochelle, real quickly. There was a question about where does community property go? So if you do have a spouse and you pass away and all of your assets are community property, then yeah, your spouse gets your half of the community property estate. And that process is actually considered it's like a fast probate. There's a probate proceeding where you file some forms with the court. This is again in the context of not having an estate plan in place. There's no trust, there's no will or anything like that. You won't have a full probate, and you won't have the full probate fees that apply if you pass away with community property and you have a surviving spouse. So the fear and the dangers of having a probate situation are sort of lessened if it's a husband and wife spouse and one person passes. But then at that point, it becomes very important for the surviving spouse to do estate planning, because then unless they want to get remarried and have everything pass to their other spouse. But at that point, it's not community property because it's separate property. So anyway, those are more complicated rules. So,
Brett, thank you so much for that clarification and for answering that additional question. Now we're going to move on to Jackie Quinn, who is a private fiduciary.
Hi, everybody. Thanks for joining us today on a Sunday afternoon. I just see I'm showing my wine rack. I'll just move over a little bit like this. This is kind of strange to do a presentation like this for us, and it's probably strange for you to participate in it. I like to do a presentation where it's sort of interactive, and this makes it a little difficult for us, but we'll power on. So I'm, as Rochelle mentioned, a private professional fiduciary. And some of you attending this probably have no idea what that means, or you have a vague idea of what a fiduciary is. It has many meanings, but in the subtext of what we're talking about, it means that I, as a private professional fiduciary licensed by the state of California, can act as a trustee or an executor, agents under powers of attorney, etc. And so some of you may be wondering, like, why would I do that? My children can do this role for me, or I have a really good friend or relative who I would like to do this for me. And I'll talk in a little bit about why that may not be a great idea. There's also corporate trustees. Those are usually banks, and they can also act as a trustee and executor. And they used to be a much more common alternative, but they have sort of moved a bit away from what I call the mom and pop trusts. They have certain dollar figure limits, and they just do things a bit differently than, say, a professional fiduciary. Typically, the professional fiduciary keeps your same financial planners and CPAs, unless they see something that really is not good that's going on. I've been doing this for about 12 years, and there's maybe 2 times where I've actually switched a CPA just because of some things that we saw that didn't look quite right. But what can happen when you don't plan correctly? Brett had a nice, presentation discussing all the things that you should be doing to prepare. But the case that he actually mentioned, he and I are involved in together, the gentleman had named a trusted friend as his fiduciary, and she was doing a great job, but he didn't name a successor to her. And unfortunately, she was killed in a tragic accident. So not only is it important to pick your maybe first person to act as your trustee and agent, but to also think ahead to who's the successor, who would that be for you? Another reason I don't think it's always a good idea to name friends are often they're the same age as you. I had another case where it was 2 best friends. They had worked together for years and years. They had bought houses next to each other in Santa Maria, and neither one of them had children, and they were going to be each other's agents, and they both ended up with Alzheimer's. And so that didn't work out very well either. So there's a lot of factors that you want to consider when you're making this decision. So I mentioned briefly powers of attorney. There's 2 different types. There's general financial powers of attorney, and I'm not going to go into the great details. Brett can do that, or if you have questions, you can email me later, between springing and the different types of financial powers of attorney. And then there's also what some people call the healthcare power of attorney, or it's better now known as the advanced healthcare directive. There is a sheet in the handouts that kind of goes over the directives that are out there. Cottage has spent a lot of time and created a really good one that you can actually download yourself and either fill in on the computer or print out, fill it out. You can register it with Cottage. So that's a really helpful form. And we also discussed the POLST, P-O-L-S-T. It's a bright pink form that stands for Physician Ordered Life-Sustaining Treatment. And that has sort of taken the place of what we used to call the DNR, the Do Not Resuscitate. It goes into much more detail than just pull the plug, because that can mean so many things. You may want to, if you're ill, you might want to attempt a feeding tube, and it may be enough to get you over whatever illness, and then you're fine. I had that experience with my own father. So it's nice to be able to go into more detail than just pull the plug. There's so much more to it. Something else that I wanted to touch on today, and just again briefly, is capacity. Legal capacity is to a much lower standard. So you may have someone that that you think it might not be competent to make a new estate plan. If it's dicey, and Brett, again, the attorneys are the ones who are really evaluating the person to see if they understand the changes that they want to make. Do they understand their estate plan? Do they know their assets and where they're going? Or if you suspect there may be problems down the road with children, etc., other people who might not agree with the changes that are being made, you can also go and see a neuropsychologist and have an exam. That doesn't come up too often, but it does come up, and it's good to have that if you're anticipating problems. And one thing I wanted to discuss and why it isn't really always a great idea to name your children in this role. First of all, it's a lot of work. For us professionals, it's our job. We know how to get things done. We know we have contacts in just about every kind of environment you can imagine. And so it's much simpler for us to distribute or administer a trust. We don't have the emotional sort of baggage that sometimes comes with this. I had a case where we were brought in because someone, one of the children was named as the trustee, and she just couldn't administer the trust. It was just too difficult. And she did nothing for several years until another sibling actually had to take her to court. And that's where we became involved to come in and just get this state administered. So sometimes it's just can be paralyzing for the child. They don't really have any nefarious motives. They just, for whatever emotional reasons, can't handle the job. And then there are, unfortunately, some of the children who are looking at the estate of mom and dad as their money. And mom and dad are, you name someone as your trustee and executor, and you think, well, they're just going to handle this when I die. But people are living a lot longer and into their 80s and 90s. And so often whoever you have named is going to be helping you in your final years, both with where you live, with healthcare decisions. So there's so many avenues to think about. And I had a case where we had two daughters. One was known as the good daughter and one was known as the bad daughter, had been into drugs, had been in jail, and she cleaned up her act. Meanwhile, the quote unquote good daughter was very systematically ripping off mom and had basically stolen about 4 properties, and mom almost lost her house by the time we were brought in to kind of fix it. So there's a lot of things that come into this decision to make an estate plan. And I know most people, when you're not doing one, it's because sometimes it's overwhelming to make these choices. But if you don't make them well and you don't have a good plan in place, you can sometimes end up in a conservatorship. And that's, I always look at as a last resort. That means that you either didn't have appropriate people that you've named, or you didn't have a plan at all. And suddenly someone needs to, make financial decisions for you, healthcare decisions, etc., because you're incapable. So that's my happy note that I'm going to end on. You just really, it is a plan. It's called a estate plan. And you really want to give thought to how you want this carried out for yourself. So I know my number's on some kind of handout in my email. So if you have any questions about any of this, I'm happy to talk to you.
Thank you, Jackie. This is Rochelle. I had a question come in prior via email from an attendee saying that she doesn't have any children, she doesn't have any living friends or relatives left, and would a fiduciary like yourself be able to handle financial as well as health decisions?
Yes, so I would say that all of the fiduciaries are very well versed in both, and it's quite often that we are doing both. It's common in Santa Barbara. I'm not sure about other cities, but I happen to be a single person with no children. And we have several clients who, even if they're married, they don't have children. So those are things that we certainly can do. We can handle the financial aspects, but we can also be named as healthcare agents. If we do that, then we have additional kind of forms that we go through, because you're basically naming a stranger to make one of the most important decisions ever for you. So we have sort of a process that we go through.
Thank you very much, Jackie. We appreciate your presentation. And now we're going to move on to our certified public accountant, Donna Dawson, who's going to speak.
Hello, everyone. I'm not sure if you can hear me. I'm not seeing my picture up there. Anyway, it's a pleasure to be with you. My name is Donna Dawson. I'm a local CPA, and I do a lot of estate and trust taxation and administration work. Today, I'm going to cover a couple of a brief overview of the estate and gift tax rules and some recent changes, some of which Brett's covered, and I'll go into in a little bit more detail, and also some planning opportunities that you might think about. So in regards to the federal and estate tax and gift tax, really it's a tax on the transfer of property from one person to another during either lifetime, you can do a lifetime gift, or at death. In California, there's no estate tax at the California level, but 12 other states have estate tax or inheritance tax at the state level, as well as what you would see for the federal level. There's also another level of tax that's related to the estate tax called generation skipping transfer tax. So if you transfer assets to someone who's 2 generations below, say your grandchild or a great grandchild, or someone who's 37 and a half years younger than yourself, there's a second layer of tax that's owed. It's still at the same rate as the federal estate or gift tax. So there's really almost a double taxation that you would face without some additional planning. And that's, you'll see that there's a lot of trust planning in regards to that generation skipping transfer tax when there's a larger estate, a significant estate. As Brett mentioned, the estate tax exemptions are pretty high at this point. It's 11.58 million per person for 2020, and it's scheduled to go up to 11.7 million in 2021. They're automatically scheduled at the end of 2025 to go back to 5 million. But again, as Brett said, with the new administration, President-elect Biden has mentioned as low as 3.5 million perhaps for the new exemption amount. Gift tax and federal estate tax is right now at 40%. Again, that could go up depending on the administration. And now for gifts. Again, as was mentioned, the gift and estate tax is a combined system. So any gifts that you give during your lifetime are considered at death, and it's a cumulative effect. But during lifetime, you are allowed to do a certain amount per year. So you can do up to 15,000 per year per person. You can do unlimited gifts to spouses, and you can do other gifts such as payment of medical and tuition, charitable gifts, political gifts that don't even count towards that 15,000 per person. Gifts are reported at the value of the gift at the date of the gift, but the basis of that property, say you give stock that's worth $100,000, but you bought it for $10,000, that $10,000 cost basis would carry over to the donee, so that if they in turn sold the property, they would have a significant capital gains. That's different than what would happen if they inherited the property after your death. After death, there's a step up in basis for the value. So that same property would have zero income tax consequences to them if they sold it after they inherited it. So there is some timing issues to consider whether to gift a property now or to hold on to it, at least under current law, when there's a step up in basis allowed. And that's part of the planning that when Brett was mentioning every 5 years or so to go in, it's really good to be talking to your tax professionals about that. For estate tax purposes, your gross estate is really, it's everything that you own. It could be retirement accounts. It'll be the assets that you put into your living trust. It'll be cash on hand, life insurance, anything that you haven't made an irrevocable gift of during life. So that's considered your gross estate when you die. And at that time, any lifetime reportable gifts that are in excess of your annual exclusion amount, those get added back as well. So the combined of both of those is really what you would look at to see whether you exceed that, as it is this year, the 11.58 million per person. Again, that may not affect you directly, but still, one of the issues you need to consider at death, even if your estate is below that level, is that at least under current law, we have a step up in basis. So you're going to want to determine what the value of your assets are, what the value of the estate assets are for the decedent, so that whoever inherits those assets gets that new basis. And in California, being a community property state, both the decedent and the spouse gets a step up. So again, it's something that if you have rental property, all of a sudden, you know, and you maybe bought it 30 years ago, now it's valued at current market value. You get another whole, you know, step with the step up, you get more depreciation. So there's really some tax benefits, but you really need to look at the numbers and do some planning, even at the first death. And if there's no tax involved, you really want to talk to your professionals at that point. Let's see, for gift taxes, there's an annual form that gets filed on the same timing as your income tax return. So due by April 15th of the following year. It's a cumulative report. So any gifts that you've done in prior years, you'll carry those forward into the new year, which goes along with that whole combined reporting for gift and estate tax purposes. Each person files their own 709. A spouse does not do a combined one the spouses do not do a combined one. At death, there's a form 706 that's filed. Again, if there's a large enough estate above that 11.58 million, or perhaps if the combined estate of a decedent and the spouse is expected to be above the exemption level, a return may be filed to use the unused amount of the exemption from the deceased spouse. It can be carried over to the surviving spouse for gift or for estate purposes, but a return needs to be filed in order to make that election. So again, it's worth checking with your attorney in that regard after the first death, just to see what options you need to take care of to get your the best results in the future. So that's pretty much it on the estate tax side. On the income tax, I was going to cover a little bit of the Secure Act, which Brett addressed. The big change regarding the IRAs with getting rid of the stretch IRA and the 10-year in exchange for a 10-year payout rule is that really a lot more planning can be done. You'll want to try and match the years you take out those distributions. If you've inherited this from someone else and it's too late to do the planning pre-death, at least you can plan for how best to bring that income into your tax returns for the least amount of tax costs. So maybe if there's a year when you have significant medical expenses, you know, that would be the year to take in more. You don't have to take it in any certain time frame. You can take it all in year 1, year 10, or whenever over that 10-year time period. So again, you should be working with your accountants probably and your financial advisors to figure out the best way. If it's a significant, you know, inheritance, how best you can bring that in for the least amount of tax cost to yourself. Also under the Secure Act, just as many of you may know, there used to be a requirement that you would take your minimum distribution starting at age 70 and a half, and that's now been extended to age 72. So it gives you a little bit more time before you have to start taking those distributions. You can also you can continue making IRA contributions after age 70 and a half, which is new. As long as you're working and still have compensation. That's a change from the prior law. And I've lost track of time, sorry about that. There was also a number of changes under the CARES Act in March of 2020, once the COVID-19 really hit strongly, and Congress made changes to the charitable contributions. They increased the amounts that people can give in cash in the current year. There was a temporary waiver so that you weren't required to take your required minimum distributions if you were of the age. and those who had taken them, there was an opportunity up through August of 2020 to repay those so that they could not have to recognize the income for the year. There was also economic impact payments, the $1,200 per person stimulus payments that many people received. There were income thresholds with that, so not everyone received it, but many people certainly did. Moving forward, there's a number of changes that we anticipate may be happening on the tax side with this new Biden administration, but some of that's going to depend on what priorities they set at Congress, whether a second round of stimulus legislation is taking place, and what other issues become more important with the way the economy is going. But some of the things they were talking about, in addition to the 3.5 million perhaps for a new exclusion amount, would be to change the increase the tax rates back up to 39.6% for individuals. A lot of this affects individuals making over $400,000. There's a possible additional payroll tax that would come into play. Capital gains may be taxed at ordinary rates for those above a certain threshold, perhaps $1 million. So again, not so much middle America is targeted so much. It looks like for the above about 400,000, but keep in mind, if you have a sale of property or something, you could get pushed up into that 400,000 level inadvertently, even if you don't normally have that kind of income rate. So you would certainly want to check with your tax advisor if that was happening.
We had a question, the Secure Act and the CARES Act, do they have an end date?
No, the Secure Act is permanent, and the same with the CARES Act, until new legislation comes in.
Great, thank you.
Right, but that's the current law. As I said, we're expecting significant changes depending on what priorities the new administration places. We're expecting some significant changes in 2021. We just don't know which way they're going to go. So that's more of a matter of keeping an eye on how the legislation seems to go. Unfortunately, sometimes in the estate and gift tax area, if they do make changes, they end up making them retroactive to the year that the legislation goes into play. We're not expecting anything in 2020, but say they don't do a tax law change until November of 2021, they could actually make it retroactive, like a reduction down to the 3.5 million to January 1st of that year. So we may not be able to plan around it, but certainly you would want to have the discussions with your professionals on that. One thing that I want to talk about on the income tax side that really affects most everybody is ways to consider is that when your income is above a certain level, 250,000 for married filing joint and 200,000 for single, there's an extra 3.8 investment tax income that's assessed. Also, higher income levels can affect the taxability of your Social Security benefits if you're receiving Social Security benefits, and also the Medicare income related monthly adjustments for the Social Security premiums that you pay. So there's many reasons to try and get your adjusted gross income and your taxable income down a bit if you can. One way to do that would be to perhaps take advantage of the opportunity to, in the years when you're required to take a required minimum distribution, to contribute that directly to charity from your IRA. That way it's not ever brought into your income. It's adjusted gross income. You don't get a deduction, but you never have to recognize the income, and you're meeting your charitable needs and commitments using pre-tax dollars. Also gifts of appreciated stock to charities rather than selling the stock and donating the cash. Again, anything you can do to keep that adjusted gross income down is going to have an effect with your overall tax level. So it can be really helpful. Also this year, especially, if you've got realized capital gains by year end, work with your financial advisor to possibly sell some of the securities that might have unrealized losses if you have some of those, and offset those and do some matching of the gains and losses so that you can minimize the tax effect. One thing that really, especially for this year, comes into play, because many people have had a loss of job and lower income is to consider a Roth IRA conversion. If you have high medical costs, if you've lost a job, if you've got lower income than normal, but you've got deductions, if you don't have enough income to use those deductions, the deductions generally are wasted. There is a carryover for charitable contributions, but most other deductions, especially for medical, et cetera, you don't get to carry those over if you don't use them. So if you have a large IRA, you can convert part of that, into a Roth IRA. So what happens there is that you recognize the income if there is income in that year. And we've got fairly low tax rates this year, so that's helpful. We expect the rates to go up. You recognize the income, or you use that to offset the deductions, the higher medical deductions, et cetera. I've got a client now, they're moving into Casa de Renta, and there's like a $200,000 medical component to the buy-in. So if they convert $200,000 of their IRA to an IRA rollover, it washes. There's no tax cost, and the benefit of having something in the Roth IRA is that there's no required minimum distributions. And when the money does come out at a later date, when you decide to pull it out, there's no income tax cost. So there's deferred growth and no income tax cost. So it can be a real win in the right situation. So just keep that in mind again, that when you've got a life-changing event, new job, maybe starting a new business, large medical costs, something else unusual in a year, meet again with your financial advisors, because there are opportunities to do some of these other planning that may not come to your mind in the normal course of events. Now, are there any questions? Any other questions, Rochelle, that have come up?
That's all we have time for right now.
Perfect.
Thank you so much for your presentation. And of course, the museum loves the idea of gifts of appreciated securities and also IRA distributions. It's really, really helpful to a lot of people, and it's certainly helpful to us. So now we're going to be moving on to Denise Stevens. She is the chair of the museum's Plan Giving Advisory Council, and we appreciate her leadership. She's a former investment and plan giving professional. Denise?
So, as we know, Santa Barbara has many great nonprofits organizations. In fact, we have more nonprofits per capita than most communities. These organizations add a lot to the fabric and value of our community. And the 100+ year history of the Santa Barbara Museum of Natural History demonstrates one of these great organizations that has served for generations and will work to do so for years to come. I want to thank them for creating this important forum to share information. So COVID on all of our minds. COVID has focused our attention on many things, including what is important to us. But even before COVID, many of us wanted to give back and had started thinking about our own legacy. In a nutshell, estate planning is kind of about getting assets to one's objects of affection in the most efficient and lowest cost way possible, and in the most appropriate ownership form, as Brett pointed out. But it's also part of the overall process of building a legacy. When we assume estate planning is only about money and property, we overlook the importance of the process and we rush through important decisions. Many people spend more time planning a vacation than they do planning their estate. But when we realize estate planning is very much about ourselves, about our values, how we live, our life lessons, and about touching the future and building a personal legacy, well, then we can be more motivated to create more effective and well-crafted plans. Plus, in addition to the personal satisfaction of making a legacy contribution to the good work of a favored organization, a properly planned gift can often provide significant personal, tax, estate, and financial planning benefits. Many of these have already been noticed. You can increase your income, you can reduce potential gift or estate taxes. You can garner favorable capital gains treatment. You can negate probate expenses. You can be remembered in a certain way. You can be recognized by an organization while you're still living. And you can even get some fun benefits like behind the scenes tours or other special invitations, which I so enjoy. So what is planned giving? Legacy gifts are usually called deferred or planned gifts. These are gifts that a charity typically gets later on. But they're an important part of estate planning, and they come in all shapes and sizes. The good news is that a planned gift is usually more substantial than you might think, and there are many ways to leave a legacy. And the best part is you don't even have to be wealthy. It comes down to a question of how to best achieve your goals. So let's talk about some of those common ways of doing things. But first, I just wanted to quickly reiterate something about cash gifts that was mentioned. An outright cash gift now would not necessarily be considered part of estate planning, but it was noted that there are some temporary changes in the tax rules for charitable cash donations just this year. And I wanted to emphasize, because usually cash donations are only tax deductible up to a certain percentage of your adjusted gross income, and only to donors who itemize their tax returns. For 2020, the limits are suspended, as Donna said. So donors are allowed a charitable deduction limit for a cash donation right up to 100% of their adjusted gross income. Now note that these donations must be to a qualified charity, not to a private foundation. That limit are also changed for contributions from corporations, where they can now do 25% instead of 10. But most importantly, this year, everyone is being allowed an above the line tax deduction for up to $300 of a cash contribution. So the change in the tax code, as I said a few years ago, eliminated the ability to use tax deductions for filers who now take the higher standard deduction instead of itemizing. But for this year alone, if you don't itemize, you can deduct up to the $300 in cash to a charity or charities of your choice. So you have a chance now to make a year-end gift to a valued nonprofit and get the deduction. But be sure to get the documentation from the charity and report the gift to your tax preparer. And if you want to make a year-end gift via a credit card, which most charities will accept, it's considered a cash gift, but be sure to check with the charity about their processing dates in advance to ensure that the credit card donation gets processed by year end. So now let's kind of move back to bequests. Brett already spoke about wills and living trusts, and he noted that wills are generally simpler and less expensive to prepare, but they can delay asset distribution when probated. On the other hand, living trusts are under your control during your lifetime. You can name a successor trustee if you become incapacitated, and the assets in your trust can avoid probate. I'll simply reiterate that charities can be named as beneficiaries in either legal document. This is usually a bequest, because many people want to give to a favored charity, but may not be able to donate cash or property during their lifetime. But a donation through your estate this way is possible. A bequest is very simple to execute, easy to implement, and convenient. These are typically gifts anyone can make. So think promise. You basically just include some magic language in your will or trust. Bequests do not take effect until death and are thus revocable. You can change it during your lifetime should your situation change. Because they are revocable, you don't get a tax deduction, but the amount given to charity is not subject to federal estate tax should the estate exclusion amount change, as everyone has noted. Bequests can take various forms, and you have some options. You can make a bequest for a specific dollar amount or for a percentage of your estate. You can also cite a specific asset, a specific account, part or all of the residue of your estate, which means what is left over after expenses are paid, and any other specific amounts go to other designated beneficiaries. That's your residue. You can also designate your bequest to be used for general use, which is usually a charity's highest purposes, or you can restrict its use. So let me refer you to the sample bequest language handout you got today in your emails. It includes many examples of suggested bequest wording. Review it later at your convenience, but if you're planning to make a bequest, be sure to capture the unique nature of the type of bequest you want to make, and never hesitate to contact the charity to confirm the wording again. And please remember to include the legal name, the tax identification number, if you can get it, and whether or not the gift is restricted or unrestricted. Name confusion, believe it or not, has caused some gifts to go to wrong organizations or resulted in very delayed gifts. This is easily preventable. And as everyone is saying, we highly encourage you to share your plans with your advisors and with the charity to ensure that the charity is able to properly follow your wishes and recognize you. And you can request anonymity if that is what your concern is. Now let me briefly talk about some assets that pass solely by beneficiary designation forms. Most notably, this would be your IRA, your 401k, 403b, and other retirement plans. They transfer solely by a beneficiary designation. So they pass outside of your will or living trust. You need to be aware of whom you've designated and whether that is still what you want. You are allowed to name a nonprofit or nonprofits as the beneficiary of a portion or all of these accounts. And when your estate is settled, the amount designated will pass to the nonprofits. And although that portion doesn't go to other heirs, it does save them, as we said again, potential estate tax issues. So this type of gift is very easy to execute, and there's no expense to set it up. There's just a few simple steps. You contact your retirement plan administrator, and you get a change of beneficiary form. Much of this is now online, actually. You provide the names and required information for all of the beneficiaries, along with the percentages for each. You can divide it any way you want, as long as the total percentage adds up to 100%. Then you submit the completed form, but make sure the administrator acknowledges it was received and processed. And it's also wise to keep a copy in your own files. So as we said, these designations are revocable during your life. And if you need to change them again, you simply need to complete another updated designation form and send it back to the custodian. They become irrevocable when you die. So bequests are something even young people can do. They can give a small amount of a retirement account to a favored charity, and this is actually a great way to act on your values and instill a lifelong philanthropic perspective. Some families even encourage this as part of a family values legacy. Many people now have very large amounts of their portfolios in one or more retirement plans. In fact, for some, it may be their largest asset. But as we've also noted, these are now becoming the most expensive for families to inherit. As Donna said, a non-spousal beneficiary of a traditional IRA can no longer defer those assets and stretch them over his or her lifetime. They now have to withdraw those funds if they inherit the IRA over a 10-year period. And while this can be done, and when you withdraw, they're subject to federal and state taxes. These accelerated distributions are thus less attractive to heirs versus other assets now. One study I read recently actually said that the acceleration of income taxes is projected to transfer over $15 billion of family wealth to the government by 2029. So reiterating, some of us may want to seriously consider IRA and other retirement accounts as a suitable vehicle within our charitable giving strategy, as they've become more expensive to inherit. And if you have more than one IRA, consider how you want to address each. And it is best to coordinate with other gifts named in your will or trust. For example, if you have traditional retirement accounts going to family members and cash from your bank account being designated to charity, you may want to consider reversing that and make the gift to charity from the retirement account to save on taxes. So you've probably all heard about the IRA charitable rollover. This gives older individuals the opportunity to give back to communities by allowing direct transfers from their IRA to a charity. It was intended to benefit donors of all incomes, as well as both large and small nonprofits. So as previously mentioned, someone over the age of 70 and a half is allowed to make a gift of up to $100,000 from his or her IRA to meet their annual required distribution. This gift can be made to a charity and thus bypass reportable income to you. It's an easy way to make a gift, but it must be made to a qualified public charity. So it can't be made to a private foundation or a donor advised fund. Therefore, be sure to coordinate with your IRA custodian and the charity to make sure it gets done correctly. If you're already taking required minimum distributions, as noted, you've heard that the IRS has waived the required minimum distribution for this year. But even though it's waived, donors age 70 and a half or older can still make a qualified charitable distribution from their IRA if they want to. It remains a viable option for philanthropic giving. And for those with larger IRAs, keep in mind that if your account continued to grow this year and you're not taking a required minimum distribution, then you're going to likely have a larger required minimum distribution next year, because next year's required minimum is going to be based on the account value at the end of this year. So keep that in mind. Just speaking personally, I inherited an IRA earlier this year from my dear cousin. As a non-spousal beneficiary, I am subject to the new distribution rules. So I have to withdraw all of the money over the next 10 years. I can do that as I choose within that 10-year period. The account value just has to be reduced to zero at the end of the 10th year. However, I need to consider my other income, other mandatory required minimum distributions, other inherited IRAs like the one from my mother, and how all of this extra income, although lovely, could kick me into a higher tax bracket in future years. And I could be at risk for the Medicare surcharge that Donna mentioned. But if I consider various gifting strategies for some of these distributions, including the IRA charitable rollover once I turn 70 and a half, it could help me with managing income, and then allow me to reassess my other assets. So there are other types of assets that pass by beneficiary designation in addition to retirement accounts. This includes life insurance, commercial annuities, and US savings bonds. Whether you have whole life, universal life, or term life policies, there are beneficiary forms involved. And much like the aforementioned retirement account forms, you can specify primary and contingent beneficiaries, and you could designate a charity as either a full or partial beneficiary for either a percentage, or you can specify a set amount. Like the retirement accounts, don't forget who you've designated. One of my husband's best friends got married, never got around to changing the beneficiary on his own life insurance. Unfortunately, passed away 3 years after getting married, and his sister got the entire life insurance proceeds, not his wife. There are various ways of making gifts of life insurance, and we don't have time to really go into any detail today. But how the gift is treated by the IRS typically involves ownership of the policy. For example, if you're the policy owner and simply name the charity as a beneficiary, there is no income tax deduction because you can change your mind. It's revocable. But if you make an outright gift of the policy, naming the charity as both the owner and the beneficiary, you might qualify for an income tax deduction. And in some cases, when you've named a charity as the owner and they're still making premium payments, you may be able to deduct those payments as well. There are other estate planning tools using insurance that might be beneficial if you have a sizable estate or young beneficiaries. Most insurance agents and professional financial advisors are well versed to speak to you about these. And some of them, as Brett noted, have lost their usefulness as well. So do consult advisors before making any changes to such assets. Now let's talk about some fun income producing gift strategies. Charitable gift annuities have become increasingly popular in recent years. A charitable gift annuity is basically a formal and an irrevocable contract between a donor and a charity. In exchange for a gift of cash or property, such as appreciated stock, the charity agrees to make fixed payments to the donor for the remainder of his or her life. The income can be paid to one or two individuals. Income is usually set up to receive immediately, although some charities will allow you to defer the income start date for a little while. While some of the large national charities advertise their gift annuity programs, most nonprofits don't offer them. I think 4 Santa Barbara nonprofits are currently licensed to do this, and the Santa Barbara Museum of Natural History is one of those. Charitable gift annuities are popular because they're simple, they're fast and inexpensive to execute, and they offer very high competitive rates. This is especially good in this low CD savings rate environment. Rates are based on a schedule, and most charities use the schedule issued by the American Council on Gift Annuities. Rates are basically a function of your age when the income starts and whether you're electing 1 or 2 life contract. The older you are at the start of the gift annuity payments, the higher the fixed rate you get. And once set, the rate never changes. You have fixed income for life, no worry about market fluctuations, and no managing assets to worry about. You can get a current income tax deduction in the year you make the gift if you itemize. And if you use appreciated stock or mutual fund shares to fund the contract, you may save on capital gains taxes as well. In addition, you get income on the full market value of the asset, not what is left over after some sale. And as a really good bonus, a predetermined portion of the income stream is tax-free. So while cash and securities are the most common funding options, a few charities can fund with real estate, although it's a lot more complex and more is involved. Different charities may have slightly different minimum ages for executing a contract or different minimum contract amounts, although the amount to fund a gift annuity is usually very reasonable. And in case you're concerned about where the assets go, the assets funding these contracts are kept segregated from the charity's own assets and are monitored by the California Department of Insurance. So there is accountability, but you still want to know the financial health of the charity. Let me show you a couple of quick illustrations of how a gift annuity works. Thank you. In this first example, hopefully you can see it, the donor is 70 years old and is electing a single life annuity funded with $25,000 in cash. She will get a fixed rate of 4.7% and an income tax deduction of $8,838 and an annual income of $1,175. That income can be paid in monthly or quarterly installments. Because a large portion of the income is deemed to be tax-free, her effective payout is really higher than 4.7, more likely over 6% depending on her tax bracket. And as I said, she cannot outlive that income. Just anecdotally, a lot of charities are convinced that once someone signs up for a CGA, they end up living a very, very long time. So at the end of the donor's life, the remaining monies go to the named charity and are not subject to probate or estate taxes. Let's bring up the second illustration for a joint life. In the second illustration, yes, thank you. We have an 81-year-old husband and a wife age 69. Because it's a 2-life contract, the rates are a little lower. They'll get 4.4%. They also get a tax deduction of $15,647, an annual income of $2,200 as long as either of them are alive. Again, because part of the income is tax-free, their effective rate is actually higher. When the second of them passes away, the remaining funds will go to the charity. Thank you. These are both cash illustrations, but you can fund a gift annuity with appreciated securities. These may have some capital gains advantages. If this is something that interests you, ask the museum or the charity to run a confidential, no obligation illustration for you to see more. I've seen some people use charitable gift annuities to supplement retirement income. I also saw a case where an unmarried, well-off woman bought separate contracts for her less well-off siblings in their senior years. The siblings all got extra income for life. The well-off sister got the tax deduction and the satisfaction of supporting her favorite charity and her brothers and sisters in a meaningful way. And remember, in 2020 only, funding a charitable gift annuity with cash will qualify you for the increase in the deduction limit up to 100% of your adjusted gross income if you itemize. And the money to your named charity in the end will benefit future generations, perhaps even your own grandchildren or their children. Another income plan giving vehicle, and Brett mentioned this, is a charitable remainder trust. A charitable remainder trust is generally used by wealthier donors as it can be costlier to set up and maintain. It's a separate tax-exempt irrevocable trust. So this is different than your living trust. And it reduces taxable income by using a tax deduction to offset other income or mitigating capital gains. Income is paid out to beneficiaries for a lifetime or for a specified period of time. And the remainder of the trust assets are designated to a charity or charities at the end. For example, the donor and spouse can be the income beneficiaries for their lifetime, or younger beneficiaries can be named income beneficiaries for a term of years. However, the charity must receive a certain minimum at the termination of the trust. This is 10% of fair market value on the gifting date. So this is a way to convert non-income producing assets to something more productive. You can basically create a charitable remainder trust, contribute the appreciated property. The trust then sells the property without paying capital gains taxes. And the charitable remainder trust pays income for the lifetime or one or more income recipients for a specified term of years for up to 20 years. There are a couple of variations, and I know we're running out of time. A charitable remainder annuity trust, the income is paid as a fixed dollar amount for every year of the trust. You fund it once and it never has to be reappraised. In a charitable remainder unit trust, income is paid as a stated percentage of the trust value each year. The trust can be funded once or you can add to it. But the trust assets get revalued every year to determine the new annual income amount to be paid. The minimum payout is 5%. And if the trust assets rise in value based on their investment, your income payout can also rise, but the reverse can also happen. There are various payout options with the unit trust that we don't have time to go into. Just know that there are options depending on the needs and ages of the income beneficiaries. A charitable lead trust is a variation of all of this. Basically, a donor makes a gift to a charitable lead trust, and the charity gets the income from that trust for a term of years or for the donor's lifetime. After that, the assets go back to the donor's designated other heirs. So you're basically temporarily redirecting income while transferring real property to your heirs. This can help minimize potential estate and or gift taxes. However, this is a taxable trust. But this strategy, the CLT will report income and take a deduction for the amount it distributes to charity. Any excess after that is subject to tax. This strategy is useful with commercial and rental property in larger estates. So a couple of us have mentioned appreciated securities, and this is one of my personal favorites. So if you have appreciated securities, I mean, the market has been going up the last few years. This is a great way to donate to a qualified charity. If you donate appreciated investments so that you've owned for more than a year, you'll get a larger deduction than those that you've held for less than a year. So maybe you have, someone gave an example before, maybe you have a stock worth 10,000, but the cost basis was only 1,500. If you sold it first, you have to pay capital gains on that $8,500 difference, leaving you with less to actually donate, maybe only 6,500. So it is good to consider donating some of the shares directly to charity. Then you get the full amount of the deduction, which, by the way, is based on the average stock price the day they receive it. You don't pay any sales commissions, and you don't pay the capital gains tax on the appreciation. The charity can provide you very specific instructions to provide your broker if you're interested in doing this. Using appreciated securities to make gifts, I believe, is going to become increasingly beneficial if capital gains tax rates rise as expected, or other changes are made in an heir's ability to receive the step up in basis, as already noted. But in addition to all that, the appreciated assets that a client might choose to designate might also solve an investment problem, such as diversification, or if the donor has an overconcentration in a particular stock. And also remember, I keep saying appreciated securities. It's not advisable to make a charitable donation with a stock in which you have a loss. In that case, it's better to sell the stock yourself, capture the write-off of the loss before donating any of the proceeds to charity. And as always, it's best to consult your financial advisors first. So there's many strategies involving real estate, and we don't have time to delve into them today, as they can be complex. But a gift of real estate and an estate plan can provide a significant benefit to a charitable organization and avoids that inclusion of that property in your estate. So if estate taxes and cost basis rules become more onerous, this could be a motivating variable. I just want to briefly mention, though, something called a life estate. A life estate involves a remainder interest in a personal residence, farm, or even a vacation home. Basically, a donor executes a deed transferring the property to a named charity, but the donor retains the formal right to use the property for the rest of her life, or as for a specified term of years. So the donor uses the property and can still live in it while alive. The charity gets the asset at the end, and the property is excluded from the donor's estate for probate or federal tax, estate tax. The donor can receive an income tax deduction. It is based on the present value of what's called the remainder interest. It's not the whole value of the property. But remember, a charity must receive the remainder interest in the property itself, not the proceeds from the sale if you sell first. There's a sequence. And there is paperwork required if any of you refinance. Some of it's similar. Title report, appraisal, inspection, transfer deed. And there's also an upkeep agreement between the donor and the charity regarding maintenance, insurance, and property taxes, which are usually still borne by the donor. So this is a strategy that may be suited for someone perhaps who is house rich but cash poor, or perhaps a donor who has a second home like a vacation cabin that she does not expect to use much after the children are grown. It's not used often, but a bargain sale is when a charity purchases a property from a donor for less than fair market value. The donor gets a charitable deduction for the difference between fair market value and the cash that they receive in the sale. It's pretty that simple. I just want to make one very quick comment about tangible personal property. I know Brett said something about it. Donors often want to give items such as artwork, collectibles, books, equipment, or other items of tangible personal property. There are a lot of IRS rules associated with any tax deductibility of these gifts. These rules have to do with the overall value thresholds, how the value is documented, how the charity uses the gift, that's very important, how long the charity keeps the item, and limits based on your adjusted gross income. So If you wish to make a significant gift of personal property, be sure to discuss it with the charity first and your advisors. In summary, let me emphasize that planned gifts have a major impact on a nonprofit's ability to support the future of their mission, and this will continue to be the case for a long time to come. Planned gifts can be a real win-win for the donor and the charity. You may want to consider some of these ideas that we've talked about today, and consider your legacy as you prepare or reevaluate your estate plan. Choosing appropriate planned gifts depends on personal circumstances and goals. It's increasingly important to examine what assets are best to give, when to give them, and how to transfer those assets so that there's no inadvertent problems. To that end, working with both the charity and your professional advisors is the best way to ascertain and achieve your objectives. By strategically selecting which assets go to heirs, which go to charity, you're likely able to give more to both. Advisors might even recommend several actions working together and other ideas you might overlook on your own. Some strategies require an attorney to draft document, but many others do not. Either way, remember you want your estate plan to reinforce your core values and legacy. It's not just shifting money. So let me just recap a few other important things. Elements of a good estate plan are intended to work together. A good estate plan will help give you peace of mind that you provided for and protected the people and organizations you cherish. And it will also better protect you in your later years when you may need to manage your property, you may need help with doctors, or help managing your financial assets. It is prudent to review your will, trust, powers of attorney, beneficiary designation forms, and all other legal documents. Make sure these documents are up to date and reflect your actual wishes. Review them again every few years or whenever you have a major life change. We all know things change. And if you haven't executed any of the necessary documents yet, get it done now. There's no time like the present. You don't want the state to decide who gets your assets, and their default plan will not include any gift to charity. Also, be sure to take steps to ensure that your wishes are known and that legal documents are secure. Have you discussed relevant plans with executors, agents, even your family? Do agents have copies of what they need? Are they able and willing to serve? All of us here today can share horror stories involving lost documents and outdated agents. And I thank my colleagues for sharing one. I have one of my own, but I won't go into it today. The museum offered a free lunch webinar on the topic of organizing and safeguarding your important legal documents earlier this year. If you'd be interested in hearing more about the subject, please let Rochelle know, and perhaps we can reschedule a repeat of that. I also want to emphasize that charities have respective policies regarding the types of gifts they'll accept, as well as the minimum limits. Discuss this in advance, and if a gift is to be used for a specific purpose, as I said, ensure that the charity is able to accommodate that purpose. Finally, sometimes personal mementos and effects, even when they have no real financial value, can cause the biggest estate disputes. Other times, your heirs don't want a lot of these things. Think millennials. Your estate plan should address how these assets will be distributed. We're actually considering doing another Lunch and Learn webinar next year on personal property. Who owns it, who gets it, various ways to distribute it. If you think you'd find this interesting, then I'm asking you to let Rochelle know that as well. And don't forget to review the handouts we've provided to you, as they contain helpful hints and tips when you're reviewing your estate planning documents. So before we turn back to Michelle, I just want to share one thing I read just a few days ago that I found interesting and had never thought of myself. If you have unused airline miles, rather than lose them, you might want to consider giving them to a charity that, if they're able to use it, perhaps flying their employees to trainings or other events. We all do look forward to the day where we can fly again. Now, Rochelle, do we have any questions?
We do. Denise, thank you for a great presentation, and thank you for sharing with us the personal stories of you and your husband. The real life stories really stick in one's memory. We had a question emailed in asking, does your health affect one getting a charitable gift annuity?
A charitable gift annuity, remember, the charity gets the assets after you pass away. I had shared that a lot of people that I know who have charitable gift annuities lived well into their 90s. They were getting an income stream that whole time, which was wonderful. But if your health is compromised, you might want to look at a different type of gift, or at least go in with the understanding that your income stream is, it's an irrevocable gift and will go to the charity when you pass away.
But there's no questions about one's health or anything when you...
No, you don't have to fill out any forms. There are no health requirements. I'm just saying, if you're looking to get income for, 30 years and you don't expect it to be 30 years, just know and go, with an understanding that assets will pass to the charity upon your passing.
Right. Okay, and then we had another emailed question. You mentioned donor advised funds. What is that?
Okay, I had skipped over this, so I'm glad this came up. Donor advised funds are a charitable giving vehicle that were created kind of collectively to manage charitable donations on behalf of organizations and individuals. You open an account in a donor advised fund. These are sponsored by like Fidelity, Vanguard, Schwab has them. You make an irrevocable donation of cash or securities. However, instead of the money immediately going to a specific charity, you retain the privilege of advising the fund managers how much and when to distribute funds at some later date. This can be an efficient and low-cost strategy for those who might want to get a tax deduction now, doing this now, but figure out exact giving later. Meanwhile, the donation continues to grow. And by the way, if you do already have a donor advised fund, this is year end. So consider some of our local charities that have been hurt so much this year.
Absolutely. Thank you for that clarification. Okay, we are going to wrap up now. We had a couple of rather detailed questions come in. So I will be addressing those next week, perhaps with other panelists, and we'll get back to you. And Denise did mention we are planning quarterly lunch and learn workshops, and these are also free, and they're put on by the museum, as well as our wonderful Plan Giving Advisory Council. These are very short, noon to 1 o'clock or 12:45. So it's a little bit shorter with very a limited topic. And I would also encourage you to visit the Museum of Natural History's website. If you go to menu and pull down support and then click on legacy giving, you'll actually go to our legacy giving page. And it has also a lot of free forms and documents such as a wills planner, estate planning guide, and it actually has a calculator that you can fill out yourself with your age and the amount you would want to open a charitable gift annuity for. And just as a reminder, all charitable gift annuities are backed by the assets of the nonprofit organization, and the museum has taken on that commitment. So you can rest assured that after 104 years, we're going to be around. So once again, thank you to the presenters, Donna, Jackie, Brett, and Denise, and also Sarah Clement, who has been our great Zoom master, and also for the support of Luke Swetland, our president and CEO, Carolyn Grange, director of development, and also on behalf of our board of trustees. Thank you, and I hope you have a wonderful Sunday evening, and thank you again for joining us. Good night.